Good morning, everyone. Can you hear me? Okay.
Good.
This is the Court of Appeals sitting today, Tuesday, the 16th of March, 2021, for the preceding criminal appeal number 2 of 2021. O.J. Campbell against the Queen. Mr. Mark Daniels of Mark Jeffrey Barristers and Attorneys is appearing on behalf of the appellant, and the Director for Public Prosecutions, Ms. Cindy Clark, appearing on behalf of the respondent. These proceedings are taken before my lords, the President, Sir Christopher Clark, and Justices of Appeal, Jeffrey Bell and Anthony Smelly. I do not see the appellant.
I believe I do.
I think I do.
I see a prisons officer.
He's in a separate
Here he
place.
is. He's coming in now.
Yeah.
Okay.
Right.
My Lord President.
Yes. Well, that's good morning, everybody. I think we have got all or most of the material that we need, but it all arrived yesterday, so far as I'm concerned. And we may find that we're missing something, but I think we've got most of it.
Could I just, before we start, ask who is the person that shows on my screen as Alcatel 3V?
I believe that is the appellant's mother.
Yes, good morning,
Right.
my lords.
Thank you.
Right,
Yes.
Mr. Daniels.
Thank you. Good morning, my lords. It's a pleasure to appear before you again. I appreciate time is of the essence, so if I may, I'll just go straight into my submissions. First and foremost, have your lordships had the opportunity to review the amended notice of application for leave to appeal, as well as the amended notice of application for extension of time within which to appeal the conviction and sentence?
Yes.
Yes.
As I understand, what you have done is to apply for leave to appeal out of time in relation to both conviction and sentence, and you've also sought leave to appeal against conviction and sentence.
Yes. I just wanted to cross all bridges to make sure that procedurally we were properly before the court.
And
we can
I
advance.
don't understand there to be any objection on time grounds.
No,
There is
I don't think that there's much objection with
No.
respect to the substantive appeal that is being proffered before the court for consideration. So effectively, if I may just go into the submissions,
Sure.
you'll see that we have filed 3 primary grounds of appeal where we effectively take issue with the procedure that was applied by counsel and the courts in finally getting to this place. And effectively, what may assist the courts is to make reference to a chronology of events, which I set out on page 2 of my submissions, my lords.
Yes.
And what you'll see is that there was on the 28th of May, 3 criminal offenses were commissioned. And what you'll see it set out is that the complainants would have been the Rubis gas station on St. John's Road, and a quantity of cash was stolen therein. And the police executed their duties quite promptly, and individuals were arrested and brought before the police station, of which the appellant was one. And ultimately, he accepted his culpability with respect to his offending behavior from the very onset.
Yes.
Thereafter, paragraph 3 on page 3 of the submissions, you'll see that the initial court appearance took place on the 1st of June, 2020, and that should be corroborated when we look at the record of appeal. You'll see at page 14 is the information of the offense. So that corroborates the submission that the 1st of June, 2020, the appellant appeared before the senior magistrate during the plea court session. The charges were read on the information sheet. And thereafter, the magistrate's court sent this matter to the Supreme Court, which procedurally would be the ordinary course of business. However, the issue that has arisen is that at the time, I must put my hand up as counsel for the appellant. I was unaware that there had been a series of consequential amendments, I understand, that effectively declared that anyone under the age of 18 years of age legally must be defined as a child. And as a result, what should have transpired is that the magistrate's court should have sent this appellant to the family court. Rather, what happened was he was sent pursuant to Section 23 of the Criminal Jurisdiction and Procedure Act 2015 to the Supreme Court. Thereafter, the appellant appeared before the Supreme Court on the 1st of July, the 1st of August, the 1st of September, the 1st of October. And it wasn't until the 1st of October 2020 that the appellant entered 2 guilty pleas with respect to counts 1 and 2 that appeared on the indictment. Thereafter, what we see is that on the 8th of December 2020, the appellant was sentenced to a period of 7.5 years imprisonment. 2.5 years were in relation to the robbery, followed by a consecutive period of 5 years for the use of an imitation firearm, together with a probation order of 18 months. Thereafter, at the time, the appellant was being held on remand, even though at the co-ed facility. As a result of the sentencing hearing, he was thereafter transferred to the maximum security unit of the Supreme Court, of the Westgate Correctional Facility. It wasn't until February 2021, through a series of circumstances where I was then made aware that this procedural irregularity had arisen. And once I was made aware of the procedural irregularity and had been able to confer with the statutes, contact was immediately made with the appellant, at which time instructions were given to try and rectify or cure this procedural defect. And so there we see, if I can invite your lordships to consider page 4 of the submissions, you'll see that on the 10th of February 2021, both the defense and Crown Counsel were in discussions with respect to this matter, and arrangements were made to produce the appellant to the family court at the time, which was being presided by the Worshipful Magistrate Anderson. And at that stage, what we were seeking to do was really rectify the fact that the appellant was being held in a maximum security prison in circumstances where the Young Offenders Act effectively says that he should not be imprisoned, especially not in that particular place. And so thereafter, what was done was the Crown Counsel had made an application pursuant to Section 82 of the Criminal Jurisdiction and Procedure Act 2015, which was intended to, and I quote, this is at paragraph 12, reopen a case to rectify a procedural error. And the error was under the basis that the case had been erroneously sent to the Supreme Court based on a misinterpretation of Section 9, subsection 2 of the Young Offenders Act 1952.
Just help me, where is that a quote from?
This would have been taken, I believe, from the submissions from my learned friends that were adduced before. And I think that her submissions were finally proffered before the court again this morning, if they didn't make it into the bundle. But essentially, it was just to identify that at this particular stage, my lord, both Crown Counsel and Defense Counsel are effectively in agreement that this error had arisen and we need to rectify it. The question was how? How do we best do that? And at the time, Crown Counsel had submitted that the Section 82 provision would have been a satisfactory way to cure this defect. Of course, at that time, what I want to do is just make sure that the appellant was in a better position than where he was being housed. And so I had supported, I make that very clear on the record, I supported the application by the Crown when it was presented to the Worshipful Magistrate. And so thereafter, what happened was that the Worshipful Magistrate did reopen the case, and she had invited Mr. Campbell, this is at paragraph 14 of my submissions, she invited Mr. Campbell, the appellant, to enter pleas with respect to counts 1 and 2 in the same manner that he did when we appeared before the Supreme Court. And thereafter, the Worshipful Magistrate ordered that Mr. Campbell be transferred from the Westgate Correctional Facility over to the co-ed facility. The unfortunate reality is that the Department of Corrections did not actually move the appellant. And what we understand the case to be is that they were operating under the fact that they had an order from the Supreme Court, which procedurally would trump the order of the Magistrates Court. So no further action was taken. My learned friend for the Honorable DPP and I worked together to try and get back before the court to see how we can rectify matters. And you'll see at paragraph 15, on the 18th of February 2021, Mr. Campbell was again produced before the Worshipful Magistrate, who confirmed in hindsight that she didn't have power to reopen the case. And she does express that she wasn't made aware, of course, of the full circumstances that this gentleman had been before the Supreme Court, been sentenced by the Supreme Court, and then moved into a correctional facility, which was contrary to the co-accused at the time. The co-accused had been sent to the Supreme Court as well, but no pleas were entered at that time and no sentencing had taken place. So that was the material difference between the two individuals. And thereafter, what was done is that my learned friend, again, I understand that all efforts were made to communicate that Mr. Campbell should not be held at the Westgate Correctional Facility. An effort was made post haste to have him transferred from the Westgate facility back to the co-ed facility. And then you'll see at page 5, we set out that on the 18th of February 2021, that's when we filed the appeal against sentence only. Thereafter, on the 20th of February, the Crown filed its submissions where it basically confirmed the position that we had all neglected to observe the age of the appellant at his first appearance in the magistrate's court, and that this error was made when the appellant was sentenced to the Supreme Court to stand trial. These are the submissions I think that have just been uploaded or should be uploaded. But if you look at the submissions that were proffered by the Crown, and of course I'll defer to my learned friend to correct anything, the appellant was then sentenced, and it was suggested and supported by the Crown that the Supreme Court did not have jurisdiction to act in that regard. And therefore, the Crown was supportive that this appeal should be allowed, the conviction quashed. And the reasons given were that the Supreme Court did not have jurisdiction to convict these or sentence the appellant. And as such, there had been a miscarriage of justice. Thereafter, on the 22nd of February, 2021, we then received the written copy of the Worshipful Magistrate's written ruling in respect of her inability to reopen the case. And it was at that junction we filed the Forms 7 and 2, within which to appeal the conviction and sentence, amended forms, I should say. And on the 24th of February, 2021, the Crown filed its supplemental submissions, where it reiterated that there was a miscarriage of justice pursuant to Section 21, and I apologize for the typo, of the Court of Appeal Act 1964. And so the crux of our submissions is that there was a procedural error when Mr. Campbell was sent to the Supreme Court, as he should have been dealt with pursuant to Sections 2(1) and 9 of the Young Offenders Act, as read with Section 2 of Part 2 of the Child Safeguarding Miscellaneous Amendments Act 2019 and Section 3 of the Criminal Code Act 1907.
What would the definition of child been before November 2019?
So I believe that it was for individuals under the age of 16.
Right. That's what I thought.
Was it 17?
And this individual was 17 at the time. And so all of us operated on the basis that he could be treated as an adult. But notwithstanding that belief, we were clearly wrong as a matter of law. And so as a result of that, what we've articulated is that the Supreme Court respectfully did not have the proper jurisdiction within which to accept the guilty pleas and then to act upon that.
Right. Just pause there for a moment. Don't go quite so far. When you say it didn't have proper jurisdiction, the position, as it seems to me, is that everything after the 1st of June
Yes.
was a nullity. The magistrate sent the appellant to the Supreme Court when the Supreme Court had no jurisdiction.
Yes, my lord.
The Supreme Court entertained a plea which it had no jurisdiction to receive.
Correct.
And it imposed a sentence
Yes.
which it had no power to give.
Correct.
The whole thing is, it might just as well have been done by an imposter.
Yes, and again,
Nullity.
if I can stress my apologies to this court, as I've expressed my apologies to my client and his family for not picking up on this point from the onset, as is my responsibility. So I will wholly accept my role in that regard. But the question is, how do we ensure that justice is met at this particular stage?
Well, yes, but the curious position that we're in now is that you, having endeavored to have the matter determined by the family court unsuccessfully, now say that the way in which it should be dealt with in order to obtain justice is that your client is acquitted. That can't be right, can it?
Well, again, and perhaps my reading of the law, again, is incorrect. And so I don't want to stand here in any way to try and mislead this court. Effectively, we concede that Mr. Campbell, on repeated occasions, has admitted his culpability.
Yeah.
That started from the police station, that continued when he went before the Supreme Court, and it continued when he virtually got back before the family court, notwithstanding the lack of procedural effect. And so I wholeheartedly appreciate the challenge that he's faced with in the context that if there's been a nullity, what do we do? And the question was procedurally, when I was looking at Section 21 of the Court of Appeal Act, the way that I was interpreting the language was that, of course, the Court of Appeal shall allow the appeal if it thinks, and I continue to go on, that the judgment of the Supreme Court, which in this case would be the conviction and the sentence, should be set aside on the ground of a wrong decision of any question of law or on any ground that there was a miscarriage of justice. In any other case shall dismiss the appeal. And I think that we can get to that point safely. The question then is obviously when we typically look at what the proviso sets out and how we go forward from there. And so when I had looked at the Section 21B, which provides that in an appropriate case, and if the interest of justice so require, set aside the conviction and sentence the appellant and remit the case to the Supreme Court to be retried. And in any such case, the court may make such order as it thinks fit for the determination of the appellant in custody pending the retrial or for his release on bail or otherwise. And the question was, and I don't mean to seem like I'm trying to be cheeky or academic, but the question was, if there was a nullity from the Supreme Court, if the Supreme Court did not have the proper foundation to hear the matter, legally, can the Court of Appeal just order for this matter to be sent back to the Supreme Court and that's it? Or would the Court of Appeal have power to send this matter right back down to the magistrate's court? Or would it be a situation where an appeal is quashed and then the Crown have the election, so to speak, to then try and bring the matter back before the magistrate's court and then have it sent properly? And so those are the decisions I think that ultimately the Court of Appeal is going to have to make in relation to how it approaches this. But when I was reading just the black letter law, the question that I was trying to apply my mind to, because I followed the submission of my learned friend in principle, what she's saying is that this individual has committed certain offenses. There's no denying that. And as a result of that, justice would demand that he's just dealt with properly. And I respectfully accept that. And then the question is, how is that dealt with properly? If it's a matter where this court takes the view that it can simply remit the matter to the Supreme Court, and then from once it goes back before the Supreme Court, if the Supreme Court is a nullity, the Supreme Court can then make a further decision to then send it back to the family court, or this court can bypass the Supreme Court and send it straight to the family court, then I will absolutely accept that as a matter of construction, because fundamentally, the appellant has committed certain criminal offenses. So there's no denying that. And I don't want to treat this as just a game to get a person who's genuinely guilty of something released from custody and no longer left with a conviction. However, the question was, when looking at the particular language, if the law is designed in such a way to only allow this court to send it back to the Supreme Court, would it then be another procedural error to do that when the Supreme Court doesn't have the proper standing, in our respectful submission, jurisdiction or otherwise?
Well,
and so that's really...
Just pause there for a moment.
Yes, my lord.
If we can't do that, that is to say, remit the matter to the Supreme Court in order for it to be retried by the family court, and either ask or require the Supreme Court to remit the matter to the family court, if we can't do that, it would appear to be the case that you secure an acquittal in every case where the Supreme Court acts without jurisdiction.
Which is not something I want to try and promote or encourage.
Well, it can't be right either, can it?
Yes, no, I accept that. I do accept that point.
Indeed, it can't be right, Mr. Daniel, because what would have happened in the Supreme Court was a nullity. And if that is so, then there's no basis on which either an acquittal or a conviction could arise as a result of our deliberations.
Yes. So then the question is, and I don't want to in any way seem as if I can dictate, but if there's inherent power within the Court of Appeal that it feels confident to send the matter straight to the family court, then I wholeheartedly accept that proposition. So it's not a situation I'm trying to get a result specifically based on the procedural irregularity, but I highlight, obviously through my reading and basic as that is, of course, and I defer to your lordship's greater wisdom and experience, then the appropriate matter, the concession I would make is that this matter should be and always should have been heard before the family court, and I don't shy away from that. The main premise of this application is ensuring that justice is met, and the manner in which we've got to this particular place is contrary to the principles of justice, such as there's been this miscarriage. And that is the crux of our argument. But as I say, it is not something where on any construction we are trying to change tax, because repeatedly Mr. Campbell has accepted his culpability, and he is willing and prepared to accept the appropriate punishment that should be imposed upon him at this particular stage. And the question is whether this court, if it did determine in the circumstances that this matter should be remitted to the family court, whether this court should then take the additional determination of just sending it, or whether this court, as my learned friend had proposed, could also look at the issue and deal with the sentencing at this particular stage.
Well, the one thing we absolutely can't do, absolutely not, is impose a sentence ourselves. The only court that's entitled to do that is the family court. The idea that the Court of Appeal, exercising some sort of, I don't quite know what jurisdiction, should impose a sentence is totally inconsistent with the statutory provisions. Your client can only be tried in the family court.
Yes.
If we were to impose a sentence, there'd be another nullity.
I'm guided, my lord.
But just can you just pause for a moment, because you
Yeah,
say
definitely.
you're not trying to change track because your client accepts culpability and that an appropriate punishment should be given to him.
Yes.
But the relief that you seek at paragraph 43 of your submissions is that we should allow the appeal, quash the conviction and sentence, immediately release him from custody, and direct a judgment and verdict of acquittal. Seems to me a pretty big change of track.
Which is predicated on what I set out was my interpretation, but what I certainly gather from the court is that the court's not with me on that point, nor do I want to continue down that track going against what the court has indicated. So where I can amend my paragraphs 3 and 4, Roman numerals 3 and 4, such that if this court is minded to remit the matter to the family court, then ultimately that is the appropriate jurisdiction that should hear this. Then ultimately I just want to make sure that justice is met. And I think that that is the extent of my duty as an officer of the court, to make sure that it's properly dispensed with.
Yes, well, despite what appears in your submissions, it appears that you accept that the right result is that the matter gets back to the family court by some means or other. And that begs the question as to how. I see what you say about section 21B.
Yes, my lord.
But it seems to me that it would be open to the court to say that a case in which the miscarriage of justice, which requires the conviction and sentence to be set aside, is that the Supreme Court had no jurisdiction to try the case anyway, the power to remit the case to the Supreme Court to be retried is enough to enable the Court of Appeal to remit the case to the Supreme Court in order for the Supreme Court to remit it to the family court.
And then that is certainly what I would ask of the court to do.
That's what you'd ask us to do.
If that is the appropriate mechanism within which to deal with this matter, then absolutely I want to deal with it properly.
Well, that's fine. If you don't seek to persuade us that that is not an appropriate mechanism, subject to discussions with my colleagues, that seems to be a mechanism we should adopt.
And I'm certainly guided, and I would invite that to be the course of action to take place from this jurisdiction going forward.
Right. Well, can we break out for a moment? And I'd like to discuss matters with my colleagues.
Absolutely. Good day, Mr. Campbell.
Are we all assembled? No. Yeah. Is Justice Smelly with us?
I don't see Justice Smelly.
No. Here's Justice May.
Right.
Excuse me.
Yes. Mr. Daniels, I'm going to ask Mrs. Clark some questions, if I may.
Yes, my lord.
The position we seem to have reached is that it's agreed that the right thing to happen is that the matter should go back to the family court by some route or other. And the question is, what is the route? And Mr. Daniels has said that if we are minded to hold that Section 21B allows us to remit the case to the Supreme Court in order for the Supreme Court to remit it to the family court to be retried, all well and good. And that may be the quote easiest, close quotes, route out. But it's arguable, and indeed Mr. Daniels has put the argument, as to whether that is a tenable construction of the relevant section. What I'd like to explore with you is what you say as to the construction of the section. We've seen what Mr. Daniels says. And B, if that section is not an available route, whether there is any other, one that suggests itself to one's mind is that we should simply declare that everything that happened in the Supreme Court is a nullity, and direct that the matter go before the family court. But that begs the question as to whether, and if so, how, we have jurisdiction to deal with that, and also jurisdiction to deal with the question of bail. So would you like to help us on those two matters?
I will try, my lords. Good morning.
Good morning.
I do submit that the Court of Appeal Act in Section 21 does give this court quite clearly power to remit this matter to the Supreme Court.
Even though the Supreme Court is not going to retry it?
So that, my lord, is the question and the definition of retrial. Because in my humble submission, remitting this matter back to the Supreme Court would procedurally reopen the indictment, which would allow the Supreme Court to then refuse jurisdiction and send it back to family court, which is what has been done for the co-defendant who had not yet entered his pleas. So we would be in a similar circumstance in this case if this court were minded to remit to the Supreme Court for retrial. It would place us back into the same position of the original arraignment day, when the Supreme Court could refuse jurisdiction and remit it back to the family court.
So wait a minute, on that basis, we, knowing that the Supreme Court can't retry it, we'll be sending it back in the court to the Supreme Court in order for it to retry it, knowing that when that happens, the Supreme Court, knowing that it can't, will send it to the family court.
It doesn't sound like a wonderful option, but yes, I think that's the only one we have available to us. I don't believe that this court has the ability, even though it would be nice, for the second option, for there to be a declaration and for it to be then remitted directly to the family court where it should have been dealt with in the first place, effectively taking us back to the 1st of June.
You say we've got no jurisdiction for a declaration.
Not in the criminal appeal realm, no.
Ms. Clark, you'll have seen the opening phrase of Section 21(1)(b).
Yes.
In an appropriate case and if the interests of justice so require.
Yes, my lord.
If one were to take the view that interests of justice in this case do not require that the matter be sent back to the Supreme Court for retrial, would you say that this court wouldn't then have the jurisdiction to simply direct the matter to go to the court which is properly seized of it, i.e. the family court?
I would say it isn't clear on that section. What I would indicate, though, my lord, is that if the court reminded, and so if it's saying in 21B that this is an appropriate case, but it's not in the interest of justice to remit it to the Supreme Court, my humble submission is that the interest of justice so require are referring to the fact that it should be retried at all. So potentially, if we're minded to extend the definition or the interpretation of this section, then I suppose we could say that it's in the interest of justice for it to be retried, but not by the Supreme Court. I'm not entirely sure if that's ever been interpreted that way, but I am open, like my friend, to any creative interpretation that allows the interest of justice to be served. I don't think either my friend or myself, well, not my friend in particular, is seeking to indicate that there should no longer be a conviction attached. It's just a matter of how procedurally we can find ourselves there.
Yes. Well, the premise of my question, of course, is that the situation doesn't seem to fit within the four corners of the statute.
Or in any statute, if I can make that humble submission.
Certainly no provision that we have seen. But does that mean that the court has no power to deal with the matter appropriately?
Well,
it is
I don't think so.
before the court. We are seized of jurisdiction. Nobody says anything else. So why ought the court not to be able to refer to the court that has jurisdiction to hear it?
Well, I would argue, my lord, with respect, that would have to be an inherent jurisdiction. It's not one that's specified in the act. I don't disagree that the court has some inherent powers. My lord may remember in the previous iterations of retrials, there used to be the warrant that had to be issued, and that was within the inherent jurisdiction of the court to have people brought back for retrial. So I do believe that it is appropriate for an inherent jurisdiction to allow this court to indicate which jurisdiction should hear the matter.
So wait a moment, let me be clear about this.
Mm.
Do you accept that we could, as part of in the inherent jurisdiction, firstly declare that everything that happened in front of the Supreme Court is a nullity?
Yes, my lord, I do.
And also, as part of our inherent jurisdiction, in the light of the fact that it was a nullity because the Supreme Court had no jurisdiction, remit the matter to the family court?
I believe so, yes, my lord. If this court is minded to make that declaration, then if the only option would be then for this court to properly remit it back to the family court. I should indicate, my lord, I did try that in my application to reopen it in magistrate's court in almost exact similar terms. So I'm quite proud of myself, but the magistrate did not find that the Supreme Court hearing was a nullity.
Well, that's not entirely surprising. It'd be very odd for the magistrate, an inferior court of record, to hold that the superior court's decision was a nullity.
Oh no, we weren't seeking to have her hold that position. It was an agreed position amongst counsel. And we had asked her to reopen the hearing at the date of sending in the effort to rectify the issue.
Yeah. But sorry, just so it was important to be clear. You accept, as I understand it, that we could, as part of our inherent jurisdiction, declare everything that happened from the transfer to the Supreme Court and onwards a nullity.
Yes, my lord.
And that we could remit the matter to the family court, again, as part of the inherent jurisdiction in relation to a matter of which we are properly seized.
Yes, my lord.
Um,
And I also hold that you can also deal with the issue of bail because the matter is properly before you.
Right. Even though we're not within 26(1)(b.
No. So yes, I agree. Even though that you're not within 26(1)(b, the appeal is properly before the court and the court has jurisdiction to deal with the custody status of the appellant.
Right. As part of its inherent jurisdiction.
Yes.
Right. Okay. Thank you. Now, thank you very much. Mr. Daniels, you can see that there are two routes. And as I understand your position, you don't mind which one we take.
Correct. As was clear from the onset, I tried to support the Crown's position of getting us back to the family court from the very onset. So
Okay.
like I said, the position that I've condensed to writing is really limited on these procedural nuances
Yeah,
and what powers
okay.
exist, but that's more
Okay.
academic than
Right. Well, on that basis, the position that we've reached is that by one route or another, and those are the two, the matter will go back to the family court. As you can perhaps perceive from the fact that I've asked Ms. Clark these questions, we're tending towards thinking that the best thing would be to declare that everything was a nullity, which it is, and
Yes.
send it back to the family court.
Yes.
Because the construction of section 21(1)(b) may require some wrenching or some generous interpretation, and remitting the case to the Supreme Court to be retried on the basis that the Supreme Court will say, oh no, I can't, doesn't seem to be a very suitable method of proceeding, or doubtful. But if that, we will have to choose one or other of those routes. But in relation to both of them, the question of bail will arise. Have you any submissions to make on bail, Mr. Harrell?
Well, I made an application before my Lord Justice Bell some time ago. And so having had the matter, the application was dismissed at that stage. I think it was dismissed primarily because this matter had to be heard here. And then once we determined what the appropriate outcome was, now that we know the matter is going back before the family court, I think it may, in the circumstances or the interest of justice, may require that the appellant remain where he is until final determination. Because one of the issues that was raised in the previous hearing before my Lord Justice Bell was obviously if he was released, and then we have a circumstance, let's say the family court was able to acquiesce to us tomorrow, just saying that might not be possible, but imagine if it was. If the guilty plea is then re-entered, which there would be no reason as to why it wouldn't, then the claim of making some kind of benefit over a period of time as to when that sentencing took place may seem unfair. And I'm not seeking to take that type of advantage based off of these procedural missteps, notwithstanding the circumstances that I would have preferred to have bail at the time that we made the original application.
So you're not urging us to...
But at this stage, no. I understand that my learned friend may be able to try and get us heard quickly for at least a mention for the purposes of entering pleas, and then we can try and proceed further. We have social inquiry reports, so it wouldn't take an excessive period of time before we could get to that ultimate sentencing hearing. And I think in those circumstances, I'm duty bound not to press the issue any further.
Okay. Well, I'm going to go back and consult with my colleagues, if I may. I'm sorry about this toing and froing, but I'm sure I understand why.
Yes, thank you.
Okay, I think we have everyone here.
Right. Well, we're very grateful to council for their respective submissions, which have been very helpful. The course that we are minded to take is this. And I'm going to say it slowly so that you can take down a note of it.
Thank you, my lord.
Because I hope, well, it's for you to say, but I hope that it may be possible to deal with this in the light of where we've got to, simply by the court making an order rather than delivering a reasoned judgment.
Okay.
Right. So what we propose to do is this. Firstly, to declare that the purported arraignment, conviction, and sentence of the applicant before the Supreme Court are null, void, and of no effect. Item 2, the case shall be remitted to the family court for trial to be heard as soon as possible. Three, the appellant, the applicant, what he is to remain in custody at the co-ed facility. Now, I've just realized we probably need to deal with the question of extension of time and leave to appeal.
My lord, I think all of those matters have already been dealt with by Justice of Appeal Bell.
Oh, have they?
Yeah, on
Okay.
the
All right.
28th.
Okay. Well, that's our attention has been drawn by Mr. Coelho to Section 8 of the Court of Appeal Act, which provides that, subject to this Act and any rules, in the determination of appeals before it, the Court of Appeal shall have all the powers and duties conferred or imposed on the Supreme Court in the exercise of its original or appellate jurisdiction. So if the Supreme Court could transfer the matter to the family court, so can we. Right. Now, can I invite the parties to draw up an order to that effect?
Yes, my lord. I can have that, since I brought the application, I can have that drafted in short order and sent to Mr. Coelho for your further consideration. And I'll send it to my
sent to Ms. Clark as well.
Yeah, I was just saying I will send it to my learner friend first, just to make sure that she's
I see.
in the language, and thereafter it'll be sent to Mr. Coelho, but that'll be done today.
Okay. Is there anything else that arises?
No, my lords, I think that covers everything. I'm thankful for your
Good.
time.
Well, we're very grateful to both of you.
Thank you.
Grateful, my lord.
Thank you.
Thank you.
All the best.